All right, good afternoon, everyone. Welcome back to another episode of The Debt Life. Today's topic, we're going to talk about making law affordable. Specifically, we're going to touch upon bankruptcy because there's a huge decision that just came out from Chief Judge Isikoff in the Southern District of Florida. So let's just jump straight to that. Shout out to Melissa who argued this, and she's an all-star attorney that really is fighting for not only low income, but all the clients, but really fighting for minorities and low income people that might not always have access to the best representation they can. Melissa really likes to step up, as does everybody at our firm. So shout out to Melissa for arguing this case. It's In re McCoy. Basically, what In re McCoy says is there are ways that you can do a pre-post payment plan for Chapter 7 debtors. So historically, what most bankruptcy attorneys would do is collect the full amount of their fees, costs, everything prior to the filing. That way their fees are secured. They're not a creditor of the estate, which could be problematic. And it was really better for the attorneys and easier for the system. What we did at Van Horn Law Group years ago, we read a case. It's called the Clark and Washington case by a judge up in Tampa, Judge Williamson, who I met at a conference, and they discussed this. And it wasn't really a big deal, but I saw the benefits to people, especially clients that were having their wages garnished or had an emergency and didn't have the full amount up front. What Judge Williamson and now Judge Isikoff say is there is a way to unbundle the services where you can do a pre-petition retainer for a certain amount and then a post-petition payment plan for the remainder of the services, as long as they're reasonable. And she put different ways in there to make sure that the client's not being taken advantage of and the laws are being complied with. So what we do at Van Horn Law Group, generally speaking, is we need the filing fee down, and Judge Isikoff actually requires that the filing fee be paid prior to filing, which that's $338 for a Chapter 7. And then you could be paid a reasonable fee for post-petition services, and the client can decide to move forward without paying for the post-petition services and do it on their own, or retain the firm to do the post-petition services. To give you a real-life example, there's a place in right up the street from us, actually, that's a restaurant that actually doesn't have servers. So basically, you're your own server. You have to order on your phone. It's called Sistrunk Marketplace, and then they deliver the food to you. So that's another version of unbundling. Now it works in that scenario because you're not the chef. I know that there's certain restaurants where they try to make you the chef. I like to go out, and I actually like getting recommendations from the server, and I like the full experience. But this is cool as well, and it allows them to reduce some of their costs while still providing great services. What we like to do at Van Horn Law Group, and actually was put in the order, that our retainers cover much more than other law firms' retainers. So if you need to negotiate with the trustee, we handle that. If you need reaffirmation agreements, we handle that. So we like to do an all-in post retainer that's going to cover everything that you'll potentially need. That way you can budget for the future instead of, okay, so well, now we need a 2004 examination, which is a deposition. Well, that's covered in our retainer. Normally it'd be $350, $450 an hour to prepare for that and attend. And those usually do last 2 to 4 hours on average. So it can double the price of your bankruptcy quickly. Now, this doesn't just apply to bankruptcy. We do payment plans for pretty much all of our services. Obviously, it would be better if everybody can come in and just write a check and say, I can cover all the expenses. But we realize, especially with COVID, people losing their jobs and everything, that's just not always possible. So we work with payment plans, whether you're going through foreclosure, whether you have a litigation matter. We certainly will work on payment plans with you. Another benefit to this Chapter 7 pre-post arrangement is that it cuts down on the Chapter 13 fee-only plans. So what other courts have seen, and what happens in the Southern District, if you were unable to come up with the fees for a Chapter 7, the attorney would offer you a Chapter 13, which is often 2 to 3 times as expensive, and keeps you in a Chapter 13 plan for 36 to 60 months with less of a chance that you're going to get a discharge rate, because in Chapter 13, you only get your discharge after you make your payments. So it's more expensive for the client, and it is less effective. We just did an analysis of our 2020 cases, And over 99% of our cases that we filed as Chapter 7 received discharges. So kudos to Terry, April, Martha, everybody working in the Chapter 7 department, Sonia, Milagros. I know I'm going to forget people, but they're really doing a kick-butt job over there, making sure that our clients are receiving their discharge. I understand that, when you're shopping for attorneys and when you're meeting with attorneys, price is always going to be a factor. That's why we work out these payment plans or 0% interest payment plans. But also remember the quality of what you're going to get. You're paying for a service. When you're speaking to attorneys, see if they're board certified. I've been board certified in consumer and business bankruptcy for years now. Where that comes to fruition, or where you're going to need that, is when it really hits the fan. When you have a trustee and aggressive creditor, you're going to want somebody on your side that was prepared for that going in. And our team certainly is and has been for years now. We have thousands and thousands of cases that we've been through, so we know what to look out for. And we realize that most of our clients, this is potentially your one and only time going through the legal process. And it's my goal to make it as easy as possible. And I know I have a team surrounding me that believes the same thing. So if you have any questions, I always start with this. If you have any questions, this is a very interesting topic to me. I can go on for hours, but I want to make sure that I'm answering your questions. The first question I see, do we have interest added to our payment plans? No, it's a 0% interest payment plan. So it's our goal to get you out of debt, not into more debt. So if there's anything that we can do to make it easier for you, we certainly do. Also, our all-in pricing not only includes the attorney's fees, but includes your filing fee, your credit counseling, everything that you're going to need in your case, helping you rebuild your credit, enrolling you into 720creditscore.com. It's going to do that as well. So we really want to make sure not only do we get your discharge, but you're able to rebuild. And then afterwards too, if you ever have an issue with somebody reporting on your credit or an issue with a creditor that we listed, we also handle that for free as well. So it's really important to understand that when you're working with us, it's not just we're going to file and hope everything works out, and if it doesn't, we're going to charge you more to figure it out or tell you good luck. Another example, I have a good friend, Peter, who actually watches some of these sometimes, who works at a dealership down the street. And I love working with Peter because when you go there, if there's any issues, he just handles it. If you want to test drive a car, it's not 97 pages of paper. It's like, all right, let's make this happen. And that's kind of what we are. That's where we are as well. It's our goal. We're attorneys, but we're in the service industry. So we want to make sure that you have a good experience with us, even if it is going through bankruptcy. Marcus, great question. Will it delay my case discharge if you're still making payments on the bankruptcy? No, you'll still get your discharge. Generally speaking, we're averaging about 97 days to discharge. The payment plan to us will not delay the discharge or the closing of the case. So it's really important that you're still going to be on the same timeline as you would be with the normal bankruptcy. So that would not impact it at all. Another question I get about is rebuilding the credit counseling, rebuilding credit after your bankruptcy. So a lot of people think 7 years, 10 years, I'm never going to have credit again. It is true that Chapter 13 is on your credit for 7 years. Chapter 7 is on your credit for 10 years. That does not mean you cannot rebuild credit and reestablish credit in the meantime. With a Chapter 7, you're going to get your discharge in 3 months. After another month after your case closes, you can start to reestablish and rebuild your credit from there. So that means applying for a secured card, applying for a smaller $250 limit card. Also, if you have if you have a mortgage that's in good standing, if you have a car payments in good standing, we do a reaffirmation agreement. That means that history, that positive history, is still going to report on your credit. I'm seeing on average, if everything goes well after your bankruptcy, 12 to 18 months, you're in the 700 credit score again. Will the bankruptcy appear on your credit? Absolutely. I tell all my clients, if you're ever applying for credit, make sure you have your 30-second elevator speech on what happened, or same thing if you're applying for a job that's going to check credit. I think that the stigma of bankruptcy is really going to be dead after COVID, because if people see people filing bankruptcy post-COVID, whether it's the truth or not, you can certainly blame it on COVID, because this is something that not only we've dealt with in Florida nationally, but obviously it's a worldwide event that has negatively impacted many people's finances. So, Ms. Cohen, if I have extra money and want to pay your fee in full, would that affect my bankruptcy? Nope, you can certainly have that option. I know some firms will give you two different prices, whether you're paying in full upfront or doing a payment plan. I look at that as you're basically charging interest without saying it, because you're just building the interest into the payment. So we don't do that. It probably would be a smart business decision, but we certainly don't want to be greedy or anything like that. We will work with people, and we don't want people that don't have the money to have to pay more. So, John, after I file bankruptcy, when will I be able to buy a home? FHA says 24 months after the filing date of a bankruptcy. That's the Federal Housing Authority. They'll back a mortgage. So that'll give you 24 months is a reasonable period. I've seen clients as soon as 12 months. I'm good. So it really depends on your financial situation and your other financial profile as well, as far as stability in your job and how you utilize your credit afterwards. Ms. Wallace, what options are available for no income debtors? Great question. So if you have no income and you have a complete inability to pay, we work with legal aids throughout the state actually now. So middle Florida legal aids, very organized. Shout out to those guys. They make it really easy to help out. And of course, my guys at Broward Legal Aid and Miami Legal Aid, they're some of the best people you could ever deal with. So if you can go to them, and then if you qualify, they may refer you over to us, and then you can get free legal advice. This really is an access to justice issue that we're dealing with, and I'm glad that we were the firm that we were able to argue, and Melissa was able to do such a good job arguing for so many people that this has helped. I see it day in and day out. As a business decision, obviously it's better to just get paid up front, because when you have to get on payment plans, inevitably things are going to happen. Life's going to happen. People are going to fall off the payment plans. You're going to have to work with them to move forward. I'm happy to say that we have filed 0 lawsuits, and we don't refer these out to collections. We work with people, and it's worked well with us. We're part of this community, and we want to make sure that our community is taken care of. I got some more questions. These are excellent questions. If I have a car lease and I'm in an active bankruptcy, can I extend my car lease? So that's actually a discussion that you have with the leasing company. If you have a relationship with those companies, generally speaking, they work it out with you, from my experience. So if you've been current with them and you've been dealing with them for years, that's certainly a good relationship to have, and they will work with you on that. So reach out to your leasing company. The timing of filing the bankruptcy might make sense to wait until you extend your lease or until you get into a new lease prior to filing. Or if you're a year out, maybe file now and allow your credit to rebuild a little bit, so the time that your lease comes up, you can rebuild from there. So yeah, keep these questions going. These are all great questions. I appreciate you guys coming in. We did get a fantastic review that if I know how to do it, we're going to share in the stream right now. I think that's showing, but if not, this is our clients are fantastic at sharing the information, and they left a 5-star review. I remember this client came in, her mom had an issue with her house, and we were able to help out, and my team really just makes people feel comfortable. So if you have any issues, feel free to come in and just give us a call. We're doing video appointments, phone appointments, in-person appointments. John Voss is actually traveling to people's homes that can't get out for whatever reason. So if we're able to help you, we're going to find a way to get to you to help you guys out. So I see that somebody asked red or white wine. Well, it depends on the day, depends on what I'm eating. I'm more of a red wine fan in general, but there are some really good white wines out there as well. Maybe we'll do a segment, Debt Life, on affordable wines that you can drink without breaking the budget and ended up in bankruptcy. Arian, if I already received a summons, how soon do I have to file bankruptcy? So a summons basically is a lawsuit. So generally speaking, in Florida, you have 20 days to respond to that lawsuit. It's not necessary to rush into bankruptcy. When you receive a lawsuit, though, you should speak to an attorney immediately and to go over your options, whether it's bankruptcy, negotiation, or otherwise. I have a client that I'm dealing with right now who kept ignoring lawsuits, judgments, orders, and whatnot. And now there's a potential writ of bodily attachment that's going to be entered, which means the sheriff comes and picks you up until you respond and listen to the judge. So I say this, I think, every episode too. If you get a lawsuit, if you get something from a judge, you have to take it seriously. If not, you're going to eventually piss off that judge to the point where they can issue a writ of bodily attachment. And that it happens, it doesn't happen often, so I don't want to scare anybody into it. But if you just keep ignoring things, it can happen. And I'm seeing creditors are extremely aggressive right now. So just be careful out there, because bank accounts still are being garnished. Wages are still being garnished. I know the eviction moratorium was just extended, but still evictions are moving forward if you're out of your lease or if there's other defaults. So the eviction moratorium is for people that were affected by COVID that just cannot afford to pay. So these landlords are finding different ways to evict without violating the moratorium. So just be very, very careful with that as well. As you might know, foreclosures are starting back up as well. The enhanced unemployment has ended. So it's really time to get your financial profile straight so that when you rebuild, you're not going to have people coming back from this time to garnish your wages or come after you. I still have clients that are dealing with foreclosures, deficiency judgments, and other things from 2008, 2009, 2010. So what some creditors will do is they'll get these judgments and just let them sit and collect interest for years until you're in a better financial situation. And then at that time, maybe you don't qualify for Chapter 7 bankruptcy, or maybe you have assets that they can collect against. So your best time to take care of your financial situation is as soon as you possibly can. Whether it's bankruptcy or negotiation or otherwise, speak to an attorney and figure it out. So if there's any other questions, make sure that you guys put those in there. This subject, like I said, I could talk about it for hours. I'm going to limit this to the 20 to 30 minutes that we normally do, so that we can it's easily digestible for you. Of course, if you have any questions, you can contact my office. The number's below, 954-637-0000. Also, you can email me directly. My email is below, or set an appointment to come meet with me. Here's another question. What is the benefit to filing for bankruptcy before versus after a judgment is placed on me? Great question. I recommend filing before you get the judgment, because the judgment is in public record. Once it's discharged, it'll show discharge. But when you apply for credit in the future, it might confuse people because there is the judgment in there, but you also have to look at that in conjunction with the bankruptcy. Also, if you get a judgment against you and it's determined that it was based on fraud or deceit or something else, it might be non-dischargeable in bankruptcy. So the bankruptcy court may not be able to look behind that judgment. So just be very careful, because that piece of paper means a lot. Once it's determined that you owe a certain amount, and potentially owe a certain amount because of, for example, a bounced check. I had one client that got a judgment against them. It was a bounced check, which means that was treble damages, 3 times the amount of the check, and potentially it was non-dischargeable. So we argued and we ended up settling that case, but it was a default judgment. They didn't fight it. They had defenses, but they didn't fight it. And then I'm stuck with that judgment. You can't go back in the past. And the worst time to fight a lawsuit is after the judgment's already entered. Appeals are not that successful. Motions for rehearing are not that successful. The best time is when you have all the facts in front of you and you can argue it. Or if you're going to file bankruptcy before that judgment is entered. Can bankruptcy stop the sale of my home in foreclosure? Absolutely. Generally speaking, the automatic stay will stop it. There are certain times where it won't, but the overwhelming majority, 99% of the cases, it'll stop the foreclosure and give you some more time to figure things out. If you have a lease in your apartment, can you stay in the apartment after you file? Absolutely. You can stay in your apartment after you file as long as you're current with the lease. There are ways to get caught up through bankruptcy as well. Marcus, if my car was repoed last night, will bankruptcy save it? That's a little dicey. Case law goes both ways with that. Generally speaking, we are able to get it back through a Chapter 13 bankruptcy and get into a repayment plan. But it depends on how aggressive the creditor is going to be on that. Caroline, if I'm up in a personal injury lawsuit, should I wait to file for bankruptcy? The answer is possibly. It depends on what the recovery is going to be, how much debt, how aggressive the creditors are being towards you. You do have to list every cause of action in your bankruptcy. So if I go to Publix today and I'm injured, and then I file bankruptcy a week from now, even though I don't have a lawsuit pending, I do have to list that potential cause of action against Publix as an asset of mine. So it doesn't matter when you file the lawsuit. If you file the lawsuit today or 2 years from now, you will have to list that cause of action, and the bankruptcy estate may have a claim on it, especially if it's just for damages and not for future medical care. So that's another question that's very fact specific that you'd want to speak to an attorney about. So if there are no other questions, I'm going to end it here. I definitely want to answer all of your questions. Now we have 3 books available, so if you need any more information, I have the Debt Life, and I have Bankruptcy in Florida and the Spanish Bankruptcy in Florida. So I had a translator do it. My Spanish isn't that good yet, but I'm working on it. But thanks again for attending this episode of the Debt Life. Of course, if you need anything from me, you know where to find me. I appreciate you guys tuning in. I'll see you in a couple weeks. Thanks.